Florida has just carried out its third execution of 2026, putting to death a man convicted of gunning down a police officer during a routine traffic stop 35 years ago. Billy Leon Kearse was pronounced dead at 6:24 this evening at Florida State Prison. In 1991, a judge asked an 18-year-old if he had anything to say before receiving a death sentence. The teenager turned in his chair, looked directly at the victim's widow, and winked. Then he smiled. 35 years later, strapped to a gurney with tubes in both arms, he spoke to that same woman one final time. He told her he was sorry. He told her there was no way his death could ever repay what he had taken. Then he asked her for something no one in that room expected. Forgiveness. What happened between those two moments is a case that went before the Florida Supreme Court 11 times, reached the United States Supreme Court 3 times, and forced every institution it touched to answer a question none of them agreed on. Whether the state of Florida should execute a man for a decision he made 84 days after his 18th birthday. If you follow cases like this one, subscribe now. This channel covers the ones that take 35 years to reach an ending. Danny Thomas Parrish was born on October 4th, 1961, in Fort Pierce, Florida. He graduated from Fort Pierce Central High School, served 3 years in the United States Navy, and joined the Florida National Guard before entering law enforcement. He started as a reserve officer with the Fort Pierce Police Department, working without full-time pay for 2 years before becoming a road patrol officer in 1988. His half-brother was a police officer in Fellsmere. Greg Kirk, a fellow Fort Pierce officer, later said Danny was the kind of person you could turn to, and he would already be there. Dennis McWilliams, who retired from the department as a sergeant in 2013, said Parrish would have become a natural leader had he been given the chance. Danny married Mirtha Busbin. They had no children. He was 29 years old in January 1991. The weekend he was killed, he had been part of the Honor Guard preparing for a Martin Luther King Jr. Day parade scheduled for that Monday. The parade happened without him. The Fort Pierce Police Department marched with a missing man formation. But the person who pulled the trigger that Friday night had a documented history that would divide courts for 3.5 decades. Billy Leon Kearse was born on October 26, 1972. His father left when Billy was 2 years old. His mother was a teenager who, according to trial testimony, drank heavily during pregnancy. Billy suffered a head injury as a toddler, and he was placed in special education programs for severely disturbed children. Teachers described him as frequently hungry, poorly clothed, and absent from school. He repeatedly ran away from home, telling authorities he felt safer in detention. Psychological evaluations confirmed he operated at an intellectual level significantly below his age. His first police contact came at age 8. The charge was being beyond control. By age 10, the record included theft and burglary. His juvenile history was extensive, but almost entirely nonviolent. He dropped out after the 8th grade. At age 8, according to advocates who later worked on his case, Billy Kearse begged officers to send him to a detention facility so he could get food. He was still on probation for car burglary on the evening of January 18, 1991, when he got behind the wheel in Fort Pierce. He was 18 years and 84 days old. That evening, Kearse and a woman named Rhonda Pendleton had picked up a pizza and were heading to the home of her brother, Derek Dickerson, where Kearse was temporarily staying after a fight with his stepfather. Kearse turned onto Avenue A, driving the wrong way down a one-way street. Sergeant Danny Parrish stopped him at approximately 7:45 in the evening. At 7:47, Parrish radioed dispatch. For the next 18 minutes, the 911 recording captured him patiently asking dispatch to search different spellings and variations of the names Kearse was giving him. None returned a match. Parrish had already called in the license plate number before approaching the vehicle. That single procedural step would become the most important investigative detail of the entire case. When Parrish moved to handcuff Kearse, a physical struggle broke out. Kearse later said he panicked because he was on probation and could not face going back to jail. During the struggle, Kearse grabbed Parrish's 9mm Sig Sauer service weapon from its holster. Witnesses heard one shot, then two more, then a barrage. An eyewitness watched Parrish stagger across the street before Kearse stood over him and continued firing. Parrish's last words, later recounted by Kearse himself, were a plea. "Come on, man, don't do it, don't do it." Kearse fired 13 rounds. 9 struck Parrish's body. 4 more hit his bulletproof vest. The weapon held 16 rounds. Kearse left 3 in the magazine. He drove away with the gun. A taxi driver heard the gunfire and used Parrish's police radio to call for help. Mirtha Busbin was rushed to the hospital through the employee entrance to avoid the crowd of officers filling the parking lot. Police Chief Gil Kurlikowski took her hand and told her Danny had been hurt. She asked if he was okay. He told her Danny did not make it. She had spoken to her husband by phone 15 minutes before the shooting. Their last words to each other were, "I love you." Because Parrish had called in the plate, investigators traced the registration to Dickerson's address. Kearse was arrested the same night. He waived his right to remain silent and confessed. He was charged with first-degree murder, possession of a firearm by a convicted felon, and later, armed robbery. Retired Fort Pierce Police Lieutenant Jim Tedder, the lead investigator, said he still relived portions of the case every day. The night of the killing, nearly every officer in the department, along with their spouses, lined the hallway of the station, waiting for information. Danny Parrish's funeral took place on January 22, 1991. Officers from across Florida attended. Mirtha, then 27, addressed the crowd and repeated what Danny always told her before leaving the house, that this was just a part of life, and that life should go on. He was posthumously promoted to sergeant. The trial began in October 1991 and moved to Vero Beach due to media saturation in Fort Pierce. The defense presented witnesses who testified to Kearse's childhood, intellectual limitations, and possible brain damage. The jury convicted him of first-degree murder. By a vote of 11-1, they recommended death. Circuit Judge Mark Chianca described the crime as heinous, atrocious, and cruel. On November 8, 1991, Kearse was sentenced to death. But what Mirtha Busbin remembered most had nothing to do with the judge's words. When Chianca asked Kearse if he had anything to say, Kearse turned around, looked at Busbin, winked, and smiled. She later said that was the moment she decided her fight would not end until his sentence was carried out. That fight lasted 35 years and 17 appeals. In 1995, the Florida Supreme Court vacated the death sentence over errors in jury instruction. A second jury, in 1997, unanimously recommended death again. The Florida Supreme Court upheld it in 2000, but the decision split 4-3. 3 dissenting justices wrote that the killing resulted from the impulsive act of an 18-year-old who functions on a low average to borderline intelligence level, with no evidence he set out that night intending to commit any crime, let alone murder. Their conclusion was direct. This is clearly not a death case. That dissent followed the case for decades. In 2022, a federal 11th Circuit judge cited those same justices and agreed. In 2025, 2 of them, now retired, wrote to the Florida Board of Executive Clemency, urging that Kearse's sentence be commuted. In February 2026, retired Justice Barbara Pariente called the case an example of the capriciousness of Florida's capital punishment system. None of it changed the outcome. The case went before the Florida Supreme Court 11 times, the Federal Appeals Court 3 times, and the United States Supreme Court 3 times. A 2026 neuropsychological evaluation placed Kearse's IQ at 75, and the evaluating doctor concluded he unequivocally suffered from lifelong diminished intelligence. The Florida Supreme Court found the claim untimely and procedurally barred. Governor Ron DeSantis signed the death warrant on January 29, 2026. Mirtha Busbin, now 60, had written to every governor. She had traveled to Tallahassee carrying an 8x10 photograph of her husband. Most of Danny's other surviving loved ones did not live long enough to see the warrant signed. His father died in 2013. His mother died in 2018. His sister had moved to North Carolina because she could not walk the streets of Fort Pierce without every block reminding her of what happened. On March 3, 2026, the United States Supreme Court rejected Kearse's final appeal without comment. At Florida State Prison, Kearse declined his last meal, met with a spiritual advisor, and received one visitor whose identity was not disclosed. He was described as calm. When the warden asked for final words, Kearse addressed the parish family directly. He said he sincerely apologized for what he had done, and that there was no way he could ever repay it, that his death would never repay it. He asked for their forgiveness. Some of his words were inaudible. He was pronounced dead at 6:24 in the evening. Jim Tedder, the retired lieutenant who had carried this case since 1991, had never attended an execution in his career. He made the drive to this one. Mirtha Busbin spoke afterward. She said she did not expect the apology. It gave her peace. She said she could forgive him. Then she said something that carried the weight of 35 years. "We did not win anything tonight. We lost another life. But we did get justice." In 2021, a life-size bronze sculpture of Danny Parrish was erected at the Fort Pierce police station. He stands there now, in uniform, the way his colleagues said he always showed up. Billy Leon Kearse was 18 years and 84 days old on the night of January 18, 1991. The United States Supreme Court prohibits execution for crimes committed before the age of 18. That legal line separated Kearse from constitutional protection by 84 days. His attorneys argued for 35 years that his brain was indistinguishable from someone younger. Every court found he met the legal threshold. Every dissenting justice who reviewed the case said it should never have been a death case at all. Danny Parrish asked the teenager to step out of a car on a Friday night. He was doing his job the way he always did. He never made it home. The woman he loved spent 35 years making sure no one forgot that. And the man who took 35 years to say he was sorry left behind a question the courts never answered and never will. Can 84 days make the difference between who deserves to live and who deserves to die? Leave your answer in the comments. If this case stayed with you, share it. Subscribe to this channel. The next case we cover will demand your attention from the very first line.